Okay, we are live. Can people hear us, James?
If you're not mute, yes.
Yep, they can hear us.
Yeah, you're good. There's already some people
Oh, really? How do you see that?
on the top. Oh, there's 0 right now. So
Okay.
yeah, it will.
It's right
it will
here.
start showing in
I
a
can
second.
see it. Okay.
Okay, so you're live.
Probably come
So
back
say
to
hello.
you.
I told people that 9:30 is when I said. But
Okay.
Well, we can let Emma talk for the first 10 minutes.
10 minutes? Okay.
Yeah.
What am I going to talk about?
You need to
Yourself.
say that we're waiting. Everybody, we're waiting to start. We're gonna
Oh,
start in a
yes,
few
we've
minutes.
got 27 listeners.
There
Hello,
you go.
everybody. My name's Emma Smith. Good morning. I am a 2L law student at Florida State University's College of Law. I've got Professor Terry Lewis with me. He teaches my evidence course. And today we're going to be watching some oral arguments for the Adelson case. So I'm glad to have everybody with us. We've got lots of people commenting already. We've got some, thanks for the comment about the nice owl.
I
That
did
was
forget to-
intentional.
I did forget to mention one thing. So if there's a comment or a question that you want to answer,
Mhm.
hi everybody. So you just go
I
right
think that's
here.
Valerie.
Yeah, you
This
go
is
right here. You
fine.
get like, for example, it's gonna show on the screen.
Oh,
People
good,
can
that's
see
a
it.
good idea.
You can even read the question. Say hi, good morning, Clarissa. And then answer her question and then get back.
Okay.
And you can click it again and it will get out of the
They say
screen.
we sound great. Thank you.
Awesome. You want to test your microphone, see how you sound, and maybe they'll
So-
tell you.
Tell us a little bit about yourself, Ms. Smith.
Well, I'm in law school. I am hoping to go into some trial litigation, so this is some fun experience for me. It looks like I think Valerie just commented, so we've got some co-students here. Yeah, she said yes, it's me. So
And what's Valerie's last name? I go by last name.
Busto.
Oh, Busto.
Yes.
Okay.
So yeah,
Ms. Busto did some public defender
yes,
interning.
she did. So that'll be awesome.
So your law school class is going to be attended, right?
Yeah, I hope so.
That's what I say, well, I know at least one of my students will be completed their assignment this morning because she's here.
Yep, here we are.
So where are you from?
I am from a very small town in Pennsylvania. Let's go Clarion, Pennsylvania. That's probably the biggest small town that's near me, which doesn't help. But it's way too cold up there. They just got 2 feet of snow. So I moved to Florida as fast as I possibly could. But it's still freezing here. So that's
Where did you
good.
go to undergrad?
I went to undergrad at Harding University. It's a small private Christian school, and I majored in criminal justice.
Is that in Pennsylvania?
It's in Arkansas, a small town in Arkansas, and I loved it. Big plug for Harding University. Their criminal justice department is wonderful. It really is.
All right, friends, I'm heading off to the First District Court of
Bye.
Appeal. See
Adios.
you. Do a good show.
Thank you.
Good luck.
Yeah, so I majored in criminal justice. One of our professors was a ex-CIA agent, so that was super awesome. Yeah, it was a lot of fun. We had a lot of on-hand experiences. We got to do a mock trial, and I took an evidence course in undergrad. So yeah, it was pretty awesome.
Oh, so you're way ahead.
I hope so.
Well, if you did mock trial, I find that, and I used to do the judging for mock trial things for a lot of high schools.
Oh, cool. Yeah.
And college too, for that matter. But they had the Florida Law Related Education always put on a mock trial thing in the spring. And I tell you what, the students were good.
Yeah, I believe it. We had fun. I mean, we weren't great by any means. I'm gonna share the link with other people, but yeah, it gave me a really good foundation in the rules of evidence, and now I'm just taking it for the second time. But we're going much more in depth than my undergrad class did,
Well, you should.
which is good.
Yeah, you should. It's on the bar exam. So.
Yes, move over here. I think that's a better, actually, no, I'm not gonna do that because I can't see a single thing. What did he do? What he said to get the comments up here? Okay. Oh, I see. Never mind, I'm gonna stay up close. I think there's some questions already.
You have better eyes than I do, so I'm gonna need to read that.
Better eyes, I don't know. Although my eyesight did improve recently, which makes no sense to me. Okay. We already have a few questions. I'm gonna go ahead and pop some up on the chat. We've got, okay, one from Omar Little. Who's gonna be arguing for the prosecution?
I believe his name is Robert Lee.
Robert Lee.
Yeah, if you look on the website, it has Tricia. Can't think of Tricia's last name, who's been around quite a while. I don't think I know Robert, but I saw his background. I saw one thing is he practiced in private practice in Live Oak for a short while, and I worked when I was in law school for a law firm in Live Oak. So there's not that many firms in Live Oak. So I wondered if it was the same one. But he's been around, I guess, I think since the mid-90s.
Okay. Let's see what else.
Yeah, Tricia Pate was on the brief, but I didn't see her listed on that.
Thank you. AA Legal Focus. She or he, I'm not sure who. Looks like she said best wishes to you in law school in my career. So thank you. I appreciate that.
The best 6 years of my life. No.
6 years. Okay, we've got Bunker Hogan saying, tell us what will happen today.
Well, maybe we should just get started.
Sure, go ahead.
Yeah, because that's what I'm going to do. I'm going to tell you what we're going to do.
Yeah.
Well, welcome to the very first episode of the Justice Chronicles, and something I hope to maybe continue. My name's Terry Lewis, and I'm going to be your host today. In a former life, I was a trial judge for about 30 years. I now do mediations and arbitrations with a firm in Messer Caparello. I also teach at the law school, one of my students here, and I help update and edit Professor Earhart's book on Florida evidence. And I also write. I have 5 novels that are published, 4 legal thrillers, 1 historical thriller, and the sequel of which is due out this December. But my most recent writing project is a nonfiction book, a book-length essay called Perceptions of Justice, which is apropos to what we're doing here today. It explores that elusive concept that we call justice and examines how do we come to decide what's fair and just, and why is it that you might see something as fair and I see it as unfair? What is it about our background and experiences, the way we look at things? So I use a lot of film clips and scenes from films, and also short stories and literature. It's the subtitle would be Law, Literature, and Film, I guess. But I often tell my students probably the best way to learn about law and justice and the conflict between the two is to watch it applied. What's the law applied in a particular actual case? And that's what we're going to do today. This is an appeal, Charlie Adelson's appeal. So I call it Anatomy of an Appeal. So we're using his actual case. So what I'm going to do is give a little background on the case for those of you that have been living under a rock for the last few years, if you're in Tallahassee. I have to be honest, I didn't follow the case as closely as some. I have a neighbor. Whenever I'm walking my dog, who sees me, she comes out and wants to talk about the Markel case. And who's doing what? Oh, Georgia Kaplan, she's just great. And, going on, knows every single thing about the case. And a friend of mine who I saw at a Thanksgiving gathering was just reciting, book and page about the whole case. But I did follow it, obviously, in the news, and I did look at the briefs, and the briefs in the case will tell you the background. So that's what I wrote down to tell you that. So a little background on the case. What was the evidence? What was the theory of the case for the prosecution? What was the theory for the defense? We're going to look at what the evidence was in support of it. And then I'm going to talk about, well, what is an appeal? How is that different than a trial? What is the procedure? What's going to happen today? What happens in an appeal? And importantly, I'm going to summarize for you what are the legal arguments that are made on appeal. What is it that the court's considering? What is the Adelson's attorney, what are they going to argue, or have they argued in their written briefs? And then we're going to take a look at the oral argument. And the idea is that a lot of times in oral argument, the attorneys get a little bit into their argument and the judges will interrupt them with questions. So a lot of oral argument is questions from the judges, which tells you maybe they have some concerns or some interest in a particular thing that wasn't really fleshed out enough in the written arguments, the briefs. So I'm thinking maybe that'll give us a little bit of a clue as how the judges might be thinking. So, and as you can see, we'll try to answer your questions along the way. So I'm assisted this morning by the lovely Emma Smith, who's there, and she is in fact, coincidentally, had no idea, but she works with James Wasiski on occasion, helping with this production. And James, of course, is helping as well. He's going to be down at the Court of Appeal.
I think people are saying to come a little closer to the microphone, so I'll bring it a little closer.
I'll move this. How is that? Is that better?
Let us know in the chat if that sounds any better. But I've brought the microphone a little bit closer to him.
Yeah, I am notoriously soft-spoken. I need a microphone. I need a lot of help in projecting. So when I say we, I mean we, because it's a joint effort. So let's get started. Can we? It's 9:30.
Yeah, let's go ahead.
3 people were already serving prison sentences for the murder of Dan Markel at the time of Adelson's trial in 2023. Luis Rivera, who entered a plea of no contest. And for those of you that don't know, no contest means I'm not saying I'm guilty, but I'm not saying I'm innocent either. I'm just not going to contest the charges. It's an option that defendants have in criminal cases. So, for example, if there might be a civil case, you have not admitted anything, but you can be sentenced the same way as if you pled guilty. Anyway, he turned state's evidence. They flipped him. So he testified against his co-defendant, Sigfredo Garcia, who was found guilty at trial 2019, and Catherine McBanawa, who was also found guilty at trial in 2022. Adelson's mother, Donna, has recently been convicted on the same charges. The prosecution's theory that's common in all of these cases is that the motive for the murder revolved around a disputed custody, a bitter custody battle between Dan Markel and his wife, Wendy. Specifically, there came a point during the custody battle when Wendy wanted to move the children from Tallahassee to Miami, where her parents live, and the judge denied that request. So the family was all upset, and so the theory is that Charlie Adelson, well, they talked about maybe, let's see if we can buy him off. Let's give Dan Markel $1 million, maybe he'll agree. Let that happen. And I think there was some kidding about, well, maybe I should hire a hitman. That'd be a lot cheaper. At the time, Catherine McBanawa was then the girlfriend of Charlie Adelson. So the theory is that she heard all this stuff, reflected on it, and said, well, maybe I'll just take it upon myself to help my boyfriend. I'll hire these 2 guys to kill Markel, and then we'll solve the problem permanently for him. And that, of course, is the theory of the defense, is that Charlie Adelson didn't know anything about it. But the prosecution's thing is, no, Charlie Adelson knew all about it. He got his girlfriend to hire these hitmen through her to commit the murder. Yet his theory was, I didn't know anything about it. Then after the murder, they come to me and say, hey, I took care of your problem for you. You should pay me some money. You were willing to pay him a lot of money, so pay some money. The jury didn't buy that theory, and they convicted him on all charges. He was sentenced to life in prison for the murder charge and 30 years each on the other 2 charges. Well, so where are we now? Well, we're on appeal, and our court system is set up where you have a trial court, then you have an appellate court. And generally in Florida, in the federal system, in most states, the structure is the same. You have a trial court, you have what's called an intermediate appellate court, where you have a right to file an appeal. And the idea being that is we want everybody to have a fair trial. Due process is a big part of justice. And so you have an opportunity to ask a panel of judges, trial judges, 1 judge, appellate court, in the district court of appeal, you have 3. And take a look at the record. The record is a transcript of the trial testimony, any conferences between the lawyers and the judge, any motions that were made outside the presence of the jury, any exhibits that were introduced at trial, and then the attorneys have an opportunity to make arguments in writing, what we call briefs, The court reviews that, and on some occasions, not very often, they say, well, I'll let you orally argue as well. And that's what's going to happen today. Getting a reversal on appeal is very, very difficult, and for a lot of reasons. Getting oral argument is relatively rare. And that might suggest, like I said, maybe they have a question about something they want to flesh out a little more. It doesn't mean they're going to reverse it. It just means that, it's a better step. When another life, when I was an attorney, I did criminal appeals for the Public Defender's Office here in the Second Circuit as a contract. Basically, I wasn't an employee. I guess maybe a special employee. But if I got oral argument, I thought, hey, yeah, that's a win. If I got an opinion, not that it was reversal, but if I actually got them to talk about the issues, that's considered, somewhat of a victory. If you got a reversal, oh my God, celebration, bring out the champagne or something. So it's very difficult, very rare. But that's the idea. Is we want somebody to look at it and make sure everything was done. Now, one of the things they're looking at is, or the argument is, well, I want you to look at this because I think the trial judge made mistakes, what we call errors, in rulings, either on motions or in evidence coming in or not coming in, and that denied me of a fair trial. So one of the things the court will look at is, well, was there a mistake? Was there an error by the trial judge? And if there was it a harmful error? Did it affect his ability to get a fair trial? You'll often see the quote about a defendant's entitled to a fair trial, not a perfect trial. So there may be mistakes. I mean, everybody's human. You may make an error, but did it really affect it? Is it more or less likely that a guilty verdict would not have been returned had those errors not occurred? So there is no evidence presented at an appeal. Like I said, all they do is review the record that's already there. You can't bring in anything that wasn't presented at the trial court. And that's a key thing too. If you didn't object, if you're the attorney and you didn't object, or you didn't object specifically and timely, you can't raise it on appeal. It's not what they call preserved. And I think we're going to see some problems with that in this case. So let's see. Let's summarize. Oh, I wanted to say just background, because like I said, all the states in the federal system have the same kind of structure, an intermediate court and then a court of last resort, which in Florida is the Supreme Court, and federal system is the Supreme Court. But they're often called by different names, which makes it very confusing. You'll have, in Florida, we have the trial court is in the circuit court, and then the appeal is to the district court of appeal, and then we have Supreme Court. In the federal system, the trial is in the district court. Well, that's outside. I thought somebody was ringing us. And the appeal is to the circuit court. So just the opposite. Then they have the Supreme Court. If you've ever watched Law and Order, you'll see when they have a trial scene and they go ding ding, they say Supreme Court. In New York, the trial court is called the Supreme Court. So whatever. It's very confusing, but they do have the same structure. So what are the arguments on appeal? What is it that Adelson's attorney are saying the judge did or did not do that was wrong that denied him a fair trial? He's got 4 issues, 2 of which concern the jury, and 2 of them of which are evidence. A Hott and a Smith, 2 evidence issues that we'll be able to discuss in class and today, perhaps. So the 2 are very related on the jury. The first argument is, you should have granted my motion to change the venue. But what does that mean? Venue is where you're going to have the trial. Under the law, trials, if there's a crime committed, it's supposed to be tried in the venue, in the place where the crime was committed. Here, that'd be the Second Circuit, Tallahassee, County. If you can convince the court that you can't get a fair trial because of undue publicity, everybody knows everything about the case, it's formed opinions about it, no way we can get a jury, then you can change it. You can go to another place. I'm old enough to remember the Ted Bundy case when it's a very nasty case. It was in the late 70s here in Tallahassee, and the judge moved the case down to Miami. And that's where it was tried. But that's pretty rare. And that was, like I said, a long time ago. Tallahassee was a much smaller community. This was it's a terrible, well-publicized thing. So usually, motions that are asked for change venue are denied, and at least the judge will say, well, let's see if we can pick a jury. Then we'll know. We'll go and we'll do the jury. If it appears that we're not able to, then perhaps I'll consider your motion to change venue. And that's kind of what happened here. And related to the second issue, which was, well, during the jury selection process, and a lot of times this happens in murder cases, the judge will first interview the potential jurors individually. The lawyers are there and the judge, and they ask questions, kind of screen them out. Don't want the jurors saying something about the case that all the other jurors hear, and that kind of taints them. And that's kind of what the defense said here was, well, while we were interviewing individual jurors, we get word that some of the jurors, potential jurors in the minority room, are talking about the case. And worse than that, they're saying, oh, he's guilty. So the argument is, Judge, well, the whole panel is tainted. You need to discharge them, dismiss them, and get a new panel. The judge didn't do that, and they say, well, that was wrong, that was error. And that's one of the issues on appeal. The evidence issues are somewhat interesting, two of them, and both of them are claims that the judge should have let Adelson present certain evidence. One of them was, well, part of the state's case was the introduction of call logs, Charlie Adelson's call logs, around the relevant times near the murder, where he is calling and obviously talking to his alleged co-conspirators. And the implication or the inference the state wants to argue that the jury can draw from that is they were talking about the murder. They were conspiring about it, talking about what's happening, what has happened, that sort of thing. Of course, it's only the call logs. Those weren't recorded. There was no reason, to get a wiretap on these phones because they didn't know about it. So what Adelson's attorney wanted to do was that, well, listen, if good for the goose, good for the gander, we got a lot of text messages, Judge, around that period of time. As a matter of fact, we got 400 text messages, 50 pages worth, which we want to introduce as an exhibit so that the jury can see that he was talking about normal stuff with these people. The judge didn't let that in. He said, well, you got a lot of stuff here and it's not all relevant. And not only that, but you've got a lot of racist and sexist and misogynist comments in there. It's going to be embarrassing. And well, we can redact some of that, Judge. And says, well, the judge says, I'll tell you what, you can show me individual text if you think it's relevant. I'll root on individual text. Well, the attorneys declined to do that. We want the whole batch in. And the batch they wanted were text messages around the June date, which was the aborted attempt to kill Dan Markel. The guys came up Tallahassee, but they kind of lost him. They followed him around. Well, we don't know where he is, can't do it. So they said, the defense attorney said, we have other similar texts around the other time, which was in July when the murder actually took place, but they never proffered those. And I don't think they proffered the ones in June. They just told the judge what they were. They must have proffered them because the judge was reading some of them. Okay. So that's the two arguments, or that's the argument on that one. Related to that was, like I said, the theory of the defense was, I didn't know anything about this, but after it happened, they started to extort money from me in order to keep quiet and for my service in having this problem resolved. He had a phone call that was recorded by the law enforcement people in which he was talking to his mother, Donna. And this occurred right after Donna was approached by an undercover agent who was trying to extort her, telling her, showed him a news article about the thing, and so I'll keep quiet, I know all about it, but you need to give me, I forget how much money, some money. And so he's talking with his mother about this, it seems, and says something to the effect of, well, no, that's not how that happens. That's not how extortionists work it. And believe me, I know. So that's essentially what he said. And the argument from the defense was that, well, that shows, that corroborates his defense theory that he was being extorted, because he's implying that he knows about how extortions work and saying this is not those same people. This is going to be, law enforcement or something. The judge said, well, no, I'm not going to let it in. It's hearsay. It's not really relevant. You can't really show how it applies. He said the argument was, well, it's an exception to the hearsay rule because it's his state of mind. It's what he's thinking at the time. So the judge didn't let that in. And they say, well, that was wrong, that was error. Now, he was allowed to testify on the first issue about the text that he was asked, well, Mr. Adelson, did you text these people back and forth a lot? Well, yes, I did. And are all those texts, you've seen those? Yes, I have. Is there any mention of murder or anything about that? No, it's all normal stuff. So basically was able to do that. And one of the state's arguments is, well, it's harmless error if there was any error because he got to testify. And by the way, one of the state's arguments about the text is that, well, these are texts not only with the alleged co-conspirators, but with a lot of other people, friends and medical colleagues, that sort of thing, which completely irrelevant. And as to the phone calls, they said, well, yes, the judge did not let that phone call be played to the jury, but they did allow another recorded phone call, which was very, very similar. So those are the four issues that are raised. Of course, the final argument by the defense says, well, maybe if not single one of these is bad enough to compel you to reverse it, put them all together and the harm is pretty obvious. So what does the state say about those arguments? We got 50 minutes, we're doing pretty good. Well, and here's an interesting thing. And early on in the evidence course, we talk about the duty of the lawyer to make a timely and specific objection and to renew that objection if necessary. So related to that, the state says, well, you know, number one, if you want to change a video, you got to put it in writing. You didn't put it in writing. It was an oral motion. Number two, you have to file an affidavit with it, which they didn't do. They did it in the middle of jury selection, which I understand. And actually, they could have requested the judge, may I have permission, time to write up, you put it in hand, write up a written motion. But they didn't do that. And probably more importantly, the argument is, well, you went through all that, but when we got time and we went through the jury selection, we had 12 people in the alternates in the jury box. The judge asked the defendant, are you satisfied with the jury? Do you accept the jury? Yes, sir. So the state's argument is, well, you accepted the jury. You can't argue now any problem with the jury because you've accepted. Your obligation, if you didn't, was to say something to the effect of, subject to my previous objections to the jury, I'll accept it. That's wasn't done there. So those are procedural deficiencies that they're going to harp on. And like I said, it's very difficult to get a reversal. A lot of rulings by the judge is under abuse of discretion. And abuse of discretion means no reasonable person could possibly have come to that conclusion. That's a very high bar. And also, if you don't object timely and specifically, you don't renew your motion, they're looking at what's called fundamental error. And the name implies, well, this is, even if you hadn't objected, it's so bad that we're going to reverse it. So that again is a very high standard. So that's the argument. As far as the merits of it, they point out, well, you know, we got a jury. Yeah, there was a lot of publicity, and you know, the defense points out that of the 54 people who said we've heard something about the case and informed the opinion of it, 53 of them said we think he's guilty. So that was part of the defense argument. But they said, well, as the judge pointed out during the trial, we've got a lot of people who say they never heard anything about the case. And I know some of you think who followed this case and weren't living under a rock, but a lot of people don't follow news. They don't listen. They don't care about it. And I think that I had that experience when I was on the bench. A lot of people don't know anything about it. And if they did, they said, well, you know, I may have heard something about the case, but I will promise you as a juror that I'll base my decision only on the evidence that's presented during the trial. And part of the defense argument had to be, we can't trust those jurors to say that they were doing that. And that goes hand in hand with the second argument, which was, you know, the jury's tainted. They've heard all this opinions of other people. But as the state points out, nobody said anything about some fact surrounding the case. Like, for example, well, Adelson gave a confession that was stricken, which is something the jury would not hear. So there was nothing that the potential jurors heard that they wouldn't hear eventually at trial. And the judge offered them, says, well, you know, you want to hear the oral or the audio in the jury room or the jury venire room, which is they record that. So anything that was said they could hear, they could come back and make a more specific case. They declined to do that. And they got a jury. There were people that didn't know about it, people that would set it aside, and to accept the defense argument, basically you would have to say, well, when the jurors came in after that, and Judge Everett, after he heard about these people talk about it, went back into the jury voir room and basically, looking sternly, I suppose, said, is there any confusion about my instructing you not to talk about this case? I should clear that up right now if there's any confusion. So the defense made some comment when individual jurors start coming back, Judge, you scared the blank out of these people. So yeah, they want to tell you what you want to hear, that they weren't talking about the case. But I have always found, in my experience, that most jurors are very conscientious. They're not going to try to evade anything. They're going to be honest with you. And so to accept that, you have to say, well, they were not telling you the truth, which on occasion happens, but it's the large part, I think not. So the argument there is procedural. You didn't reserve your argument in number two is even on the merits. If we were looking about it and say it's a valid motion, it wasn't sufficient. The judge did not err. And if he did, it was harmless. So that brings us to the other two arguments. What's the state say about those? Well, the text messages, and I read the briefs and I considered it's kind of confusing. Obviously, if you have text messages and a basic understanding of hearsay, and Ms. Smith, we haven't gotten to hearsay yet, but everybody kind of understands that hearsay is something that was said outside of court, not in court. So you have a statement. These text messages are out of court statements. So the question is, are you offering those to prove the truth of what's asserted? If it is, it's hearsay. The argument is it's not hearsay because we're not offering it for the truth of what's said in it, only just to show the nature, the subject matter of those texts, to show we weren't talking about murder. And they say, and if it were hearsay, there's an exception to the hearsay rule that allows hearsay if it shows the existing physical condition or state of mind of the declarant, the person that's talking. So their argument from the defense is, well, that's the state of mind. You know, that's what he was thinking. He's telling his mother that this is not extortion. Well, the argument counter to that would be, well, no, your belief, your opinion about something is basically what you're saying. You don't have to say my belief, my opinion. You're making an assertion that this is not extortion. This is not how extortion works. You're not even saying I was extorted, but that's the implication. That's the inference that the defense wants to draw. So you're offering this out of court statement for the truth of what he is saying. Oh, that's the phone call. Sorry, the texts are different. The problem with the text is, yeah, it's hearsay, but it's not offered to prove the truth of the matter asserted. So that's not really a problem. The question in the text, to me, is really relevance. And what they did, I mean, the state says they invited error. I'm not sure about how that is inviting error, except they're offering the whole batch. Well, say, well, is there any probative value to the fact that I had text messages with these co-conspirators, alleged co-conspirators, and other people that show I wasn't talking about murder? Very, very little probative value, if any. And certainly communications with other people have nothing to do with the case. So I think they made a mistake by saying, oh, we want to introduce the whole batch. If they said, Judge, we've got text messages around the same time as these phone call logs are, that show we were talking about something else. Yeah, it doesn't show that we weren't talking about murder, but it is relevant to go to that. But and if there are racist or misogynist or similar comments in there, those can be redacted. That would be relevant, admissible, but I think they made a mistake by insisting on the whole batch because none of that other stuff is relevant. And the judge has the authority and probably the obligation to keep extraneous, irrelevant, and probably confusing and misleading information from the jury. So it's not always an all or nothing situation. I went on all in. No, the judge is saying, give me some individual ones and I'll take a look at them. They never did. So that's the problem with that argument. The phone calls, as I was suggesting, talks about, well, that's the state of mind. Well, you can introduce the existing state of mind if your existing state of mind is relevant to the elements of the offense. thinking that that I have been extorted is not a then existing state of mind. It's, I'm telling you what happened. And I don't think this is an extortion. Well, it's only relevant to prove that he had been extorted. That's not what he said, but that's the implication. So assume he had said, listen, I was extorted by these people, so I know what an extortion is, and this is not the same way you do it. That's what you're suggesting those words mean.
I don't mean to cut you off, but I think we can go ahead and start sharing our screen with with the live stream.
All right, they're about to start oral argument.
So give me 1 second, everybody. I'm gonna go ahead. I did have somebody ask, and I think maybe you can kind of go into the procedure of the oral argument, what it's gonna look like. Somebody did ask how long it's expected to take, so maybe you could, while I'm live streaming this.
Yeah. They vary depending on the oral argument, but the court in this particular case has given each side 20 minutes to present their arguments, and that includes any time the judge is taken asking questions. And typically in almost every proceeding, the plaintiff or the prosecution, or in this case, the appellant, the defense is the appellant, gets to go first, and they usually will ask for some period of time, some minutes for rebuttal. So they make an argument. The state, or the attorney general in this case is the state, will make their argument, and then they'll have a chance to rebut.
Thank you. Okay, guys, I'm gonna go ahead and let this. Oops, sorry. Let this go ahead and start playing.
Yeah, there may be a few minutes before they get started. I'm looking. I don't think this is the right one.
You don't think so?
Let me see a second. I can't. Yeah, I think it is. Okay.
Okay.
I recognize over there. You see the guy walking around is Michael Ufferman. I've known Michael for a number of years. He was a law clerk to Florida Supreme Court Justice Major Harding back in the day, and he specializes in post-conviction relief motions and appeals. And it's interesting, but a lot of times you think, well, why don't we have the same people that tried the case do the appeal? But people specialize, and a lot of lawyers, smart lawyers, will have somebody in the courtroom with them during the trial who has experience in appeals to make sure you do what you need to do to preserve whatever issue comes up. But so it's not unusual at all to hire somebody else to do it. And you also notice that the state is not going to be Georgia Kappelman or Sarah Dugan, who were the trial attorneys doing the appeal. Almost always in that situation, the prosecution is represented by the attorney general. Interestingly enough, we have 3 judges there, and one of the judges, I'm trying to remember which one, I think it's Judge Winnicor. Judge Winnicor used to be the Deputy Assistant Attorney General who did criminal appeals and has appeared in this court, first TCA in the U.S. or Florida and U.S. Supreme Court. So he has a lot of experience in there. So if he has questions, he's gonna know that. The other judges, Lori Rose, has probably been there the longest. She was appointed by Rick Scott back in 2009, I want to say. And the other judge is Kimberly Thomas, who was appointed by Rick Scott in 2016. So it was probably Charlie Chris that appointed Judge Rowe. I may be confused, but they all have extensive experience, and they've all been on the court for some period of time.
Okay. There's James right there.
Oh, there's James sitting there. Okay, there he is in the audience.
Some people are asking whether or not you think Charlie will be at the.
Charlie will not be there. The defendants almost rarely, well, I've never heard of a defendant appearing in an appellate court. There's no testimony to be given. He doesn't get to see the witnesses against him. They're hard to witness. He's already seen that, so he's not entitled to be there. Now, they may have arranged, like some of you are doing, we're doing right now, to live stream it
Mhm.
to him in prison, but I don't know. Normally, you just wait for your attorney to get in touch with you and say, well, how'd it go? Well, it went pretty bad. Or, went good. We had some good questions, whatever it is.
Okay.
Yeah.
Well, people are just saying thanks. The students are lucky to have such a good professor. Thanks for explaining it so clearly and easily.
Well, let me thank my wife for sending that in. Yeah, I don't know who that was.
And I see we also got quite a few people from abroad. We've got some from Sweden and Australia. So that's pretty cool.
Welcome to Tallahassee.
Looks like we're getting started, so I'm going to go ahead and put the volume on.
All rise. First District Court of Appeal is now in session. All who have business before this court draw near, give attention, you shall be heard. May God save you, the United States, the great state of Florida, and this honorable court.
Please be seated. Good morning and welcome to the First District Court of Appeal. We have one case on the docket today, Charles Adelson versus State of Florida. Counsel, when you're ready, you may proceed.
Good morning. May it please the court. Michael Luffman on behalf of the appellant, Charlie Adelson. Seated with me at counsel table is co-counsel Laurel Cornell Niles. I'd like to reserve 5 minutes of my time for rebuttal.
So noted.
I'm hoping to focus the beginning of my time this morning on the first two claims, which are the jury selection claims, and I think they're intertwined. And then I also intend to briefly address ground 3. So let me begin with the jury selection claims. Claim 1 concerns the trial court's failure to grant the motion for a change of venue. Claim 2 concerns the trial court's failure to strike the panel, and then specifically, as that issue evolved, to strike the middle group of jurors 51 through 102, for reasons that I'll get into in a second. Let me begin with the change of venue argument. The numbers in this case are pretty striking. We know that of the 130 jurors who were questioned individually, and that's the way this process went. The judge began jury selection by individually questioning jurors in groups of 50. There were 3 total groups that were ultimately questioned to determine whether or not they've formed an opinion about the case and whether or not they've been exposed to pretrial publicity. Of the 130 that were questioned, 54 said that they had formed an opinion regarding innocence or guilt, and 53 of those had formed the opinion that my client was guilty.
And they were excused for cause.
They all
correct?
were.
All right, so let's start a little bit about the procedure that the rules require before those interview questions are even asked. Why don't you address, the rule requires a written motion, an affidavit, and a good faith statement, correct?
Yes, Your Honor.
All right, and that didn't happen here.
No, Your Honor.
And what type of things would we have seen in an affidavit before any jurors were interviewed?
I don't know. And my response to that is, and I understand that I'm attacking the rule and it's a requirement, although there's certainly case law that says that if a motion in any context is made orally, and if there's a component within our criminal procedure rules that requires it to be written, if it would be a useless gesture for such a motion to be submitted in writing when it's been thoroughly discussed and ruled upon orally, then that's not required. And I think that, again, specifically applies to this type of case. We know the Florida Supreme Court has been very clear that change of venue claims almost always need to be considered during jury selection, that a judge is not going to grant a change of venue claim pre-trial.
Sure. But one of your arguments is that the Tallahassee community, almost 300,000 people, was so tainted by what you characterize as pervasive media that there could be no jury selected that would be impartial. And wouldn't affidavits have shown, for instance, that, what types of media that the citizens of Tallahassee in this community were consuming? And you definitely see in the record the local sources, national sources. You make the argument that this isn't like the 1994 trial of Danny Rawling in 1994, where people would watch Dan Rather or Tom Brokaw. And I think that's right. But wouldn't the affidavits also have shown that maybe consumers curate their media differently? We saw in this transcript, there were many consumers of media who said, I'll give some examples. They don't watch television. I turned off my propaganda box 3 years ago. I don't read the paper. That's for wrapping mullet. Very rarely do I watch the news. And so you see a lot of behavior in this typical kind of Tallahassee community that's different than 1994. Couldn't you have shown those things in an affidavit before you interviewed a single juror?
Clearly, the rule says that should have been done, and I'm not disputing that it should have been done, but I submit that it was established by the record as you just indicated. The record very clearly shows the way that the 130 jurors that we're talking about consumed their information about this case. And it's not just, contrary to what happened in 1994 or what was happening in the 90s, it's not just the print media. Clearly, the Tallahassee Democrat covered this case extensively. It's not just the local news. Clearly, the local news covered this case extensively. But unlike the 90s, now we have several jurors saying that they're getting their information from cable news networks, Court TV shows.
YouTube, Court TV, 2020, Over My Dead Body podcast, The Preston Scott Show, Tallahassee Democrat. But what you don't have in this record is how many times those exposures happened, whether they were biased or not, whether there were some broadcasts or podcasts that in fact argued that your client was innocent. We don't have the content of that to show how that would have influenced the veneer, correct?
We do not have that from affidavits pre-trial showing the things that you just mentioned, but we do have that in the record based on the answers that the jurors gave. And again, when we are talking about a little over 40%, that's a huge number. In the Murphy case, I believe it was right around 25%. And in that case, the court said that's not enough. Here we are at 40%. So when you talk about 40%, when you talk about the judge making a finding when granting the protective order pre-trial that Tallahassee is in fact a small community, when you talk about this case has been permeating Tallahassee media sources for almost a decade at the time of this trial. When you talk about there was 3 previous prosecutions, one of which resulted in a mistrial and a subsequent trial just a year before my client's trial.
Sure, but why don't we talk about what the Florida Supreme Court says when there's pervasive media? Certainly no one would argue that there wasn't pervasive media in the Danny Rawling case, right?
Correct.
We're talking about 5 murders, college town, again, maybe a small community as you would describe it, perhaps.
Sure.
So with that, since that case, in the Ellerby case, the Armstrong case, the court has said that it's not enough to show that media was pervasive. It was, could the juror be impartial? Every single juror seated in this case said that no matter what contact, many of them had no contact with media or information, that they could be impartial. Isn't that right?
That's correct.
All right. So specifically, I'd like you to address the Armstrong case. The state raised it in the answer brief, and you did not address it in your reply brief. The Armstrong case, the Florida Supreme Court, and this is 24 years after the Manning case that you cited in your case, they said that if you don't renew your objection to the jury before the jury is impaneled, in fact, your client accepted this jury, that you have waived it and we may not reach that issue. What do we do with Armstrong?
So two responses to that, 3 actually. Just quickly regarding my client accepting it. I don't know that my client accepting it matters much. I think the concern is, did defense counsel renew the objection? The state made an issue out of that. And if you look at the question asked of my client at the conclusion of jury selection, the judge literally says, you have no choice but to accept because you have no strikes left.
But was there an objection?
I understand. But again, so that I'm just responding to the concern. I understand the state raised it, and that's probably why you're saying it, but my client accepting the jury is irrelevant to this matter. The question is, did defense counsel renew the objection? I acknowledge that generally is what's required for any type of jury selection claim. However, Manning is specifically a case where we know from the dissenting opinion, the request to change venue was not renewed.
But I'm going to repeat, Manning was decided 24 years before Armstrong in 2003, where the Supreme Court specifically said the failure to renew is waiver of the claim.
I understand.
That's precedent that's binding on this court, is it not?
The court doesn't, we're all familiar with the principle that a court doesn't overrule itself sub silentio. The court has not specifically said Manning's no longer a good law. That being said, I rely upon Manning because it was ultimately reached consistent with what I think the U.S. Supreme Court has said is an appellate court's burden to go through the record in one of these cases to determine if there's a change of venue issue. But beyond that, I will acknowledge that at the very least, to the extent that this court finds it is not preserved because it was not renewed, then the question is it fundamental error? And I submit that based on the facts of this case, we do meet the fundamental error standard. In the Smith case just 4 years ago, the Florida Supreme Court specifically said that the failure to preserve a change of venue claim can nevertheless be reviewed under the fundamental error standard.
Well, my understanding is, the reason we have this very, very unusual requirement for, a renewal of an objection is not just simply, it's not just Simon says, just you got to do it twice or else. It's that it is possible that the defense is happy with the jury. It's generally in the challenge context when you challenge a juror and they want to see whether you renew that challenge, that you are in fact satisfied with the jury. So I don't know if you can say that it's a fundamental error issue if in fact the defense was satisfied with the issue. Now, I did believe when I saw Armstrong, it's like, wait a minute, it's not what happened in Joyner. It's not a cause challenge, it's change of venue.
Correct.
But when you read Armstrong, it's very clear. First of all, it says that a change of venue motion is premature until you actually attempt to select a jury. What
Correct.
that says to me is a change of venue is a jury selection issue.
Sure.
And what I draw from that is that, just as Judge Rowe is saying, if you in fact are able to find jurors who swear that they are untainted, then I don't know if there is in fact a change of jury issue. It very well may be that the defense thinks, okay, I found untainted jurors. I don't really have any reason to continue with a change of venue objection. So that raises two things. Number one, whether the fact that you have untainted jurors overcomes the fact that the community may have had a low level of taint. And number two, the suggestion that it's fundamental error when the whole point of the objection is that the defendant is satisfied, which I don't think a fundamental error claim can overcome.
So a couple of responses to that. Again, the Smith case is 2021, and it's specifically page 28 of the Florida Supreme Court's opinion. And they clearly went on to address the claim for the change of venue motion, despite the fact that it was not preserved. And they did so under the fundamental error standard. And so I'll quote from the case.
But isn't there a difference between preservation and waiver?
Sure. Well, yes. But so if we're going to waiver, and now if you're addressing what my client said at the conclusion of jury selection, that's no waiver on my client's part when the judge specifically told him, you have no choice.
I guess perhaps I should just read Armstrong again, because Armstrong says a motion for change of venue should be renewed at the conclusion of jury selection or be considered waived. So it is the failure to object that is the waiver in this context. I mean, do you read it any differently than I do?
If that were the case, then Smith in 2021 would be wrong. And Smith obviously is more current and specifically says that because the issue was not preserved, because it was not renewed at the conclusion of the jury selection proceeding, we review this claim for fundamental error. So I submit to you, again, this court has the ability to review the claim. Smith from the Florida Supreme Court very recently has said, for at least a change of venue claim. It may be different for a peremptory challenge, the failure to grant a cause challenge, but when it comes to change of venue, the Florida Supreme Court has specifically said it can be reviewed for fundamental error. And I guess going back to Manning, and I understand the time difference, but Manning would be a great example of that. You literally have the attorney in Manning saying at the conclusion of jury selection, I believe we picked a fair and impartial jury. And I submit that there's no jurist in this state that would review the facts and reach a conclusion, unlike what the Florida Supreme Court did, that there's no way that venue could have been fair within Columbia County in that case. So that's exactly why these claims can still be reviewed for fundamental error.
Just generally speaking, normally when we talk fundamental error, it's because that an error wasn't preserved below. Can
Correct.
Fundamental error be affirmatively waived?
If defense counsel had said, if the question rather than to Mr. Adelson, do you accept this jury? And let me point out, you have no choice but to accept the jury, but answer me anyways, do you accept this jury? If it had been defense counsel, you previously raised some objections. Do you now no longer renew those objections and accept this jury? If that would be the case, I would have no ability to make an argument in front of you today. That would be waiver. That's not at all what we have in this record. I think the
It
fact.
sounds to me like you're going up a 3850 avenue, but let me ask you this question. Is Armstrong's a 3850 appeal?
Correct.
The other cases we're talking about earlier were direct appeals. Is
Correct.
that distinguishable?
Perhaps. I mean, again, a lot of times when the Florida Supreme Court considers 3850s, they also consider 9.141s in the context of failure to raise issues on direct appeal. And that's also the way, in Hilton at least, that the ways these claims are being raised. But again, no, in a direct appeal claim, on a direct appeal, the issue is it preserved? If it's not, can it be reviewed for fundamental error? I submit that there are some things that cannot be. Generally speaking, the failure to renew a cause challenge is not something that's going to be reviewed for fundamental error. The court's been clear about that. And if there is a specific waiver on the record, we don't have that here, then no, you wouldn't be able to review it for fundamental error. Waiver trumps fundamental error. We don't have a waiver here, and I submit that fundamental error is still the standard.
But surely you're not arguing that now a trial judge has to, who's represented, a defendant's represented, now a trial judge has to look to the defendant who's represented by counsel to say, do you individually accept a jury?
I have no idea why the judge did that in this case. But
are you promoting a bifurcated question by a trial judge to counsel and a defendant?
I think in the context that the judge is asking the question in this case is it fairly could be construed as, do you have any other strikes? And that's why, and every time that question was being asked, there was a strike because there were back strikes in this case. So ultimately, when he just asked the same question he'd been asking up until that point, the question was, do you accept this jury, i.e., do you have any other strikes? And I guess let me throw out there, you have no other strikes, so you have no choice but to accept the jury. That's why it's being said here. Again, I acknowledge it's incumbent upon defense counsel to jump in and specifically say, we renew the objection, but if that's not done, it's still reviewed for fundamental error. I see that I'm getting my rebuttal time. I would like to make a couple other quick points about the merits.
I'm going to extend your time by 5 minutes. I'll do the same thing for the state.
Thank you. I appreciate that. I do need to address. So we have, and I've already talked about this, the almost 40 or a little more than 40%. We have the Tallahassee community. We have the different ways that social media infects jurors in a community now. But we have more than that in this case. In Patton, the U.S. Supreme Court said exactly this. Adverse pretrial publicity can create such a presumption of prejudice in the community that the jurors' claims that they can be impartial should not be believed. The U.S. Supreme Court is saying.
And they're saying that, and they probably are saying that on a record where there was a record that the media exposure was indeed adverse.
Well,
and again, we can't presume that.
Let me go further with that, Your Honor. What they're saying is there could be such intense media influence in a case that we may not even believe what the jurors are saying. And if I came to you with no evidence in the record and said, that's what we have here, you would say, Mr. Rufferman, you're speculating. We have 2 instances where jurors lied directly to the trial court, asked point blank.
Are we supposed to just assess the credibility of these jurors? Is that what an appellate court is to do under this theory?
No, but what we have in this record is 2 instances where jurors were specifically asked, have you formed an opinion about guilt in this case, or have you posted anything on social media about this case? In both instances, the jurors said no. In one case, thanks to good defense counsel, good lawyering, they had a couple of posts from that juror and presented them to the trial court where that juror had said that the parents of Professor Markel should assist in killing Mr. Garcia, and then went further when my client was charged and said, surprise, surprise, Mr. Adelson is charged. But the worst one is by far the next one. Mr. T is how I refer to him, as the first initial of his last name. Mr. T stood in front of the trial court and when asked, have you formed an opinion about whether or not this defendant is guilty? He point blank told the court, no. Lo and behold, 2 jurors later, Miss M comes in and by happenstance is asked the question, has anyone been discussing this case amongst the jurors? Oh, why, yes. In fact, that gentleman that was just excused with the glasses, what's he been saying? He's been going around telling other jurors that Mr. Adelson is guilty.
And both of those jurors were excused for cause, were they not?
Yes, but statistically, if those two, it's very hard to prove someone's lying. Usually you rely upon some luck or some good lawyering with coming up with the post. So we know that one juror reported the other juror, and that's how we know that juror was lying.
And then being careful, defense counsel was offered the opportunity to review the tapes of the jury assembly room to see what comments were made, what are the reactions of the other jury members, and defense counsel said, no, I don't want to see it.
But here's the problem with that. And going to the second claim now. The second claim is a very specific, easy fix. We know for the second group of 50 jurors, 51 through 102, problems were happening. We know about halfway through jury selection, it's reported, number one, that jurors have not followed the judge's direction. So much so that the judge, when he heard about this, after two of the jurors reporting that the jurors have been talking about the case, goes out and admonishes those jurors pretty sternly, do not talk about this case. But we also know—
But the problem is the content of those communications. And they were like this, high profile case. It's the Charlie Adelson case. It's the Dan Markel case. Which of the, and that he's guilty. But again, the trial court offered your client the opportunity, the defense counsel, go listen to the recordings in the assembly room and you can bring back some statements that would in fact taint the jury. How did these statements taint the jury?
We have four statements, right? So we have one where a juror said, we've been talking about it all day, is literally the quote. We have another where there's some pretty—
Talking about it, I mean, content. Let's get to the content.
Talking about the case all day.
Again, but that you could have questioned those jurors to get specific information on what content tainted the jury.
Okay, that's one juror. A second juror then said that there had been a lot of talk about he's a professor at the law school and revealing a lot of the facts about the case. There was a divorce going on between the professor and the wife, but the two that are far the most concerning are the two jurors that specifically went back, a male and a female, the one with the glasses and then an older female that went back and told the other jurors he's guilty. In fact, if you look at juror C on page 2581, you have, coincidentally, when she's asked, after she reports that she's heard that this female juror is saying that he's guilty, oh, what's your opinion? I think he's guilty too. This is influencing that set of the panel. So let me come back to why I think this was an easy fix. There was 3 groups of 50. It was clear 8 of the jurors that sat on the jury came from this middle group, 51 to 102. At the midway point, the judge admonished the jurors to no longer talk about the case again. And the judge said, from this point forward, every juror, we should ask them, have you been discussing the case? Of those 8 jurors that came from the middle group, 4 preceded those 2 things. So for those 4 jurors, we have no, and I can quickly tell you the page numbers regarding those. I have the names. I apologize. I will say them. It's Brazos, 2467. It's Kraft, 2497. Milne, 2514. Hawley, 2528. Those 4 jurors were all exposed to
somebody saying, I think that the defendant is guilty.
Yes. Multiple times.
Okay, so they rendered that. So you have jurors who probably shouldn't be serving and didn't serve, is my understanding.
How many other were influenced by
expressing
that?
their opinion that the person was guilty? But don't we typically, we're going to strike a panel, we'll require the striking of a panel when facts come in that would otherwise not be admissible. Isn't that the typical standard for striking a veneer?
Strike 50 jurors, just those 50. The clerk actually
That's fine,
said,
but the reason for it isn't that somebody has rendered an opinion as to the guilt of the defendant. It's whether they've been exposed to facts about the case that would otherwise have been inadmissible.
oh, I don't agree with that, Your Honor. Jurors constantly saying, when they've been told not to talk about the case, talking about the case and saying he's guilty and being exposed to that, when you already have all of the social media presence that's involved in this case, that's improper. And again, the fix was easy. When they weren't sure in the third group of 50 whether or not they were going to finish, the clerk said, we have another group of 50 downstairs. How easy would it have been for the judge to say, wow, I mean, he was mad, you could tell. I'm frustrated. They're not following my directions. They're lying.
Couldn't we have sidestepped some of the speculation if the tape of the jury assembly room had been reviewed and then some content specifics argued?
I think it's clear that this 50 was tainted. And if you go back to the Manning case, what the Florida Supreme Court said that every reasonable step should be taken to preserve a defendant's trial by an impartial jury. And to this end, if there is a reasonable basis shown, the court should take action. There's, without question, a reasonable basis. We have one juror that said, you living in Tallahassee, you'd have to be under a rock to know about this case. Another juror said, the impact that this had on me, when you hear about this, it sticks with you. We have so much about this case, but then when you boil it down to that middle 50, and we know that there's not one, not two, 4 different jurors that has disclosed that they've been talking about the case, and it's getting the judge frustrated. He has to re-admonish them, but he doesn't go back and question the ones that have already been questioned about whether or not they've heard discussions from other jurors. And 4 of those jurors who were never questioned ultimately sat on this jury. That's a reasonable basis for the judge to have taken the easy step. You're right. At this point, I'm frustrated. They're not following my instructions. 51 through 102, they're done. Let's bring up the next 50. I will be very clear going forward. He was. And if we need to go to the 4th 50, we will. That's what should have been done. And because of that, my client didn't get a fair trial. I'll reserve my last minute for rebuttal. Thank you.
And I will extend you an additional 3 minutes, and the same for the state. So you'll have a total of 8 extra minutes.
Thank you.
May it please the court. My name is Charlie Lee. I work for the Attorney General's office and I represent the state of Florida in this case. I'd like to start out with the questions the judges here have asked today. One thing I do want to clear up is the preservation issue that Mr. Adelson claims in Manning in his reply brief. He talks about that in that case, the attorney below never filed a written motion, didn't renew his objection to the jury or anything like that. Those facts come from the dissent in Manning. The 3 justices of the Florida Supreme Court who felt that Manning should not have his conviction overturned, who felt he did get a fair trial, noted that his attorney affirmatively accepted the jury. Now from Manning, we've come to Armstrong. And Armstrong is backed up by all the cases where we have Batson challenges. If someone files a Batson challenge saying they didn't have a fair jury because of the demographic makeup of their jury, if they affirmatively accept that jury, then they've affirmatively waived that objection. They have to do it once again. They cannot accept the jury like Mr. Adelson did twice to his jury and to the alternate jurors.
But isn't really, change of venue is not the same as failure to renew specific challenges to specific jurors. It is a much broader, as Mr. Offerman was talking about. It has to do with what was known by the community. It's whether the community is one that cannot hear the case. It's not necessarily about individual jurors. So why should we apply this rule that I understand what Armstrong says, but I've also read Joyner, and I know that that's where the Supreme Court first made this rule very, very clear, and they made it in the context of challenges to particular jurors. Why should we apply it? Forget what Armstrong says. Why should we apply it?
You should apply it because it is about individual jurors. Because Mr. Adelson, he's entitled to an impartial jury. He's not entitled to an impartial community or city or world. There are people out there who are going to prejudge Mr. Adelson's case. There's people out there that will prejudge every case. In every jury selection, there will be jurors on the panel that will say that they believe the defendant's guilty just because he's sitting in the defendant's seat. That happened in Mr. Adelson's case. It'll happen in every case that's tried this week at the Leon County Courthouse. It has to do with the actual jurors. One of the things that Mr. Adelson brings up in his reply brief is structural error, and I'm going to explain why this isn't structural error, although Mr. Adelson has waived that because he didn't bring it up in his initial brief. But let's look at the 12 actual jurors that served on Mr. Adelson's jury. Adelson accepted all 12 jurors during the pre-screening phase. All 12 said that they would be fair and impartial. Mr. Adelson gives us no reason to believe them. As Judge Thomas pointed out, there's not a clear record here of why we shouldn't believe them. And Judge Rowe pointed out, because affidavits weren't filed in this case, we don't know what the pretrial publicity is. This isn't like Shepard v. Maxwell. This isn't like Irvin v. Dodd, where, Mad Dog Irvin was in the press, as serial killer in the press all the time. It's not like those cases. We don't know because Mr. Adelson didn't file a legally sufficient motion.
But he did show that of the 54 prospective jurors who had a considerable amount of media exposure, that 53 of them found that Mr. Adelson was guilty and said that they couldn't be impartial. Now, there's much of jurors might be lying about whether they had the exposure. Is it also possible that jurors were lying that they couldn't be impartial and absolutely thought he was guilty to get out of jury service? I mean, I think there's a lot of speculation going on here that we really can't get to.
Well, that's where I point to Singer, a case that Mr. Adelson relies upon. And in that case, and this is a 1959 Florida Supreme Court case, they said that the Florida Supreme Court said they had some doubt as to the impartiality of a fairly large number of the veneer men, which might be indicative of the inhabitants generally of the community. But we cannot determine error on doubt. That's the Florida Supreme Court in Singer.
So would it have been different, for instance, if Mr. Adelson had brought forward evidence that there were 100 broadcasts on the Preston Scott Show, that there were 200 pieces by WCTV, 300 articles in the Democrat, 50 podcasts and court TV programs, and that all of the speakers in those programs, or some high percentage of them, pointed to guilt for Mr. Adelson? Would that be different?
It might be different. All we have is secondhand knowledge of the jurors that were there. That's all we have. It might be different. We have, I think the court TV host is the only one that we know expressed a negative opinion.
And even the jurors who were interviewed about their exposure to the media sources I just listed, some of them found that those sources were credible, and some of them found that they weren't credible. They called into doubt whether the person who was on one of the news programs was partial or not, right?
Correct, Your Honor. And as to Mr. Adelson's numbers, I disagree. I noted he quotes 29 jurors in his initial brief. I noted 22 that said they couldn't be fair and impartial. But even saying it's 40%, which I believe is what he's arguing today, that's a far cry from Irvin, where it was 2/3 of the jurors had extreme bias against Mr. Irvin. I mean, he was a serial killer that in the press, I believe several states had, sheriffs had said that they were going to make sure that he died, was executed. One of the cases, Murphy, and I do agree, Mr. Adelson, there are some similarities between issue 1 and 2. And moving on to issue 2, we have to give jurors credit. Just because this young man said that Mr. Adelson was guilty, and another man may have forgotten what he posted on Facebook about Mr. Garcia, that doesn't mean that the entire jury pool was tainted. As Judge Thomas pointed out, the defense counsel was given an opportunity to go back and review video of the courtroom or the jury assembly room, wherever this happened. They were moved from the jury assembly room to courtroom 3G, and the defense declined. So we don't know, there's no indication that this young man stood up on a chair and yelled this out at the jury pool in general, or whispered it to someone. We don't know. As far as the gentleman with the Facebook page, we don't know exactly what he posted about Mr. Adelson, other than he said something about surprise, surprise. And the defense counsel didn't establish a record. And again, going back to Singer, we're not going to reverse this case based on doubt. This isn't a case, because this is not a structural error. And neither the U.S. Supreme Court nor the Florida Supreme Court has ever held that a failure to change a venue, or denial of a change of venue motion, or prejudice within the community, or bias amongst prospective jurors has ever resulted in structural error or per se reversible error.
Didn't the Manning court, though, suggest that a venue error is a structural error?
I don't think so, Your Honor, because they looked into, the majority in that case looked into the individual facts, case by case. When we get to Rawling, there and McCaskill, there the courts, and that came long after Manning, they've developed a test to find out. And this is why, in this case, we had two voir dires. We had the pre-screening process and then the actual voir dire, which is, far more than the average defendant gets. And that's so we can suss out and we can identify prejudice amongst those jurors, because no court has ever held that, bias amongst jurors in the jury pool would result in a structural error, because that doesn't affect the framework. Now, if there was something inherently wrong with the voir dire process, perhaps. Now, no courts held that either. But in this case, there was no problem in the voir dire court. The judge here went above and beyond by having the pre-screening process, then the voir dire, where counsel will get an extra chance to challenge jurors. One of the things in this case is the defense counsel didn't ask for any extra peremptories. He didn't even use all 10 of his peremptories until the very end of the voir dire process, which is a factor in Manning. And it's why we have those factors, is because with structural errors, those are errors that are so, such as a right to an impartial judge. It's not like we can question a judge, or the right to a defendant's right to represent themselves. We can't question a defendant about why he wants to do that. Or a public trial. If there's no public trial, we don't know what happened. We can't peer in. We can't look behind the veil and see what that error might have caused. But in this case, it's perfectly clear. Mr. Adelson agreed to 58 jurors. The jurors that served on his jury, only one of them heard another juror talking. 3 of them had no prior exposure to the case. And and all of these jurors, Mr. Adelson agreed to.
Could you address, the preservation issue aside, let's go to, can you address Mr. Ufferman's fundamental error argument?
I don't think that he can show fundamental error, because he can't show that in any other venue that Mr. Adelson would receive a fair trial. This case, in modern cases often, fair trial, a different trial, a different result. Fundamental error requires the defendant to show that a different result, but for the lack of change of venue, that his case would have ended up differently. Well, that's not the case here. There's been no demonstration of that.
So it's not just fundamental error that he didn't get a fair jury. Wouldn't that be fundamental error in and of itself, regardless of what the outcome of the trial was?
Well, if he could show that he didn't get a fair jury, but he certainly did.
Well, that's his claim.
Well, it's his claim, but he hasn't shown any evidence of it. He hasn't shown why this particular jury, these 12 jurors, were so biased that, that the outside influence on these jurors would have changed their verdict. He's made no showing of that whatsoever. He didn't try to poll them. They polled them after the trial, but he didn't try to question the jurors or anything like that. There was a motion later, but there's no evidence in the record that these jurors were influenced. Like I said, 3 of them had never even heard about the case. So there's no evidence in the record whatsoever that his actual jury, because he has a right just to a impartial jury, that they were influenced by the media and the local, the conversations around Tallahassee influenced their verdict. There's nothing.
I think his argument is that the media saturation implicitly biased the jurors. I think is one argument. Maybe another argument is that they are lying. They were lying when they said that they could be impartial. And he's pointing to the 2 jurors who did in fact lie. And then again, he points to the 53 of the 54 jurors who were excused for cause because they had consumed the media and felt that they could not be impartial in this case. So that's the evidence he's pointing to. What do we do with that?
Well, Mr. Adelson is asking this court to presume prejudice there, which is something that this court could only do under a structural error argument, which he's waived, and no court has ever held that it's a structural error. This court should not presume error. And Mr. Adelson has not proven any error. He hasn't proven by not filing a legally sufficient motion with affidavits that show what the media coverage was. We had that in Foster. In Foster, the defendant there filed news clips, articles that were far more negative against Mr. Foster than anything that we heard. All we have is secondhand accounts from other jurors or prospective jurors about what the media publicity was. But assuming what they said was true, what happened in Foster was far worse, and what happened in Rawling was far more extensive. And this court, there's no reason this court should presume prejudice. There's no reason this court should find prejudice if Mr. Adelson hasn't proven it, and he has not.
Well, Mr. Adelson argued in the brief, or counsel argued in the brief again, that the media environment in the Rawling case in 1994 is substantially different than it was when Mr. Adelson's case went to trial. What do we do with that?
I don't think that's necessarily true. We don't know much about Mr. Adelson, the media coverage around Mr. Adelson, but in this day and age, no media is really local. And in this case, there was over the My Dead Body podcast, there was national news. People were following this all over the country and all over the world. The environment hasn't really changed. Really, the important thing is local sentiment. If it's something that shocked the community, this is as bad as Dan Markel's murder was. 30 people on the jury, prospective jurors, had never heard of the case. In a town like Tallahassee, where people are coming and going quite a bit, it's even less than, in Gainesville, sort of the same situation with Rawling, but in Foster, that murder there with the extremely negative publicity didn't warrant a change of venue. And Foster was after Rawling. So I don't know that, I understand Mr. Adelson's arguments at times have changed, but I don't think people have. It's when we do go to pick a jury, we ask jurors, in that community, can they be fair? What have they heard? Can they set these things aside? Because after all, that is the standard in McCaskill, not whether they've been exposed, but whether they can set aside that exposure.
As long as we're talking about distinguishing the Rawling case, does it matter that we have a notorious murder and we have a lot of media from it? In the Rawling case, we had a literal serial killer on the loose, killing people. I don't think anybody in Tallahassee believed that somebody was going to pay Garcia and Rivera to come up to Tallahassee and kill them. That was not an irrational belief in Gainesville when there was somebody who literally was brutally killing people day after day for a while. That has nothing to do with the media coverage. That has nothing to do with what was happening in 1994 when he was being tried. But does it have anything to do with the decision of whether to change venue when you have something well beyond the media in assessing how the community may have felt?
I agree, Your Honor. In Rawling, the Associated Press described him as the next Ted Bundy, basically. And there is that fear and that shock. And I don't want to downplay Professor Markel's death. It was shocking. It was terribly sad. But you're right. It was certainly figured out that this was a murder for hire. And by the time that Mr. Adelson went to trial, this court had already affirmed Garcia's conviction. This was a murder for hire plot. The people in the community were not at danger as they would have been with Rawling or Bundy or even Foster with his Lords of Chaos group. I agree with Your Honor that when that fear stays in a community, that can certainly poison their minds. But in this case, that fear that would have been there in Rawling and Gainesville in the 90s would not apply to Mr. Adelson's case. And like I said, it's not surprising that only 22 jurors said that he could not set this out of their mind. I know
Isn't there a difference here, though? I mean, unlike the Rawling case, there's been, now 12 years of sustained media coverage. There have now been 5 convictions in this case. And at the time of the trial, there had been 3 prior to Mr. Adelson. Doesn't that make a difference?
I think it can work both ways. I think the saturation and the fact that this case has been going on for so long may dull the senses of people. They hear about it, they get disinterested the more they hear. I mean, but I think one of the factors in Rawling is the time of the publicity and the trial itself. In Mr. Adelson's case, the crime was far removed. 9 years, is one of the jurors pointed out, prospective jurors pointed out. But the nature of the coverage matters a lot too, and the nature in relation to the time of the trial. And there's nothing in the record to indicate there was a negative publicity about Mr. Adelson around the time of his trial that would influence the jurors to reach a guilty verdict instead of an innocent, or sort of acquitting him.
And again, that's perhaps where an affidavit may have come in and to help the defense in terms of how many media stories there were within the relevant period, the content of those stories. Again, we don't have that in the record. We just have sporadic references in the record where jurors were reporting that they had seen some media at some time.
I'd argue it's why the rule exists. It's why the rule requires.
As long as we're talking about
affidavits.
the rule, counsel, I noticed, Armstrong talks about how a change of venue motion is premature until there's been an actual attempt to impanel a jury. I understand what they're getting at just on its face, but I'm having trouble understanding how that requirement it plays into the requirement that there be a written motion for change of venue. Do you try to, do you attempt to impanel a jury, and then when you can't, you say, hold on, Your Honor, give me a few minutes so I can write out a motion for change of venue because the rule requires it to be in writing. In other words, is the requirement to be in writing unrealistic given the separate requirement that a motion is premature until you attempt to impanel a jury?
No, Your Honor, the rule is not unrealistic because it requires the defendant to make the initial record that he needs to make. And that is, if the defendant files the motion before trial and has the affidavits, which he should, like some of these cases, they went around town doing polls. And in Foster, they got the news coverage and everything before the trial. So it incentivizes a defendant to go out, get the information, poll the community, make the record for their motion, file the motion ahead of time. The court's under advisement that this is an issue, which in this case, it was an issue even before jury selection. The court then, the judge in this case, then wisely took the effort to have a pre-screening process and a voir dire. And so the rule is not unrealistic. Now, the Florida Supreme Court says that we have to go ahead and try to pick a jury anyway to see if we can determine whether there is, a bias within the community that can't be overcome. But we have to test that. That's one of the reasons I'm arguing it cannot be a structural error, because this is something we can palpably test. And so that's why I believe it's not, the rule makes a lot of sense that it requires a pretrial motion with the affidavits. To conclude, I'll move on to issue 3 briefly. I think in this case, one of the things I want to argue about the evidentiary issues is Mr. Adelson's, when he brought his text messages to the court, he never took the opportunity to untangle them for the trial judge. And the trial judge should not have been required to do that for Mr. Adelson. And that's why I'm arguing it's not just unpreserved, it's an invited error, because when the trial judge asked Mr. Adelson, if you can get some texts for me that are relevant, that would show what you're trying to prove, he just said all of them.
But that is their argument. Their argument is all of them should have been admitted, not 1 or 2 that the judge might find relevant, but all of them. How can you waive that argument simply by refusing to cherry pick ones?
Because the only relevant arguments would have been if there were any relevant. I argue that even these weren't relevant, but the conversations between Meg Benoit and Donna Adelson and Wendy Adelson, he didn't separate those out and offer those to the court and say, these are the relevant text messages, and this is why they're relevant. He should have done that. The judge was under no obligation to untangle those for Mr. Adelson.
And I think there was concern about the content of the message. I think you characterized the messages in your brief as racist, misogynist, and sexist. And I can imagine that had those been admitted, Mr. Efferman might be right up here arguing unfair prejudice against his client because of this bad character evidence.
Correct, Your Honor. The judge has to act as the gatekeeper of evidence in every case. And in this case, we may have very well had an ineffective assistance of counsel in the face of the record argument had the judge not asked pointed these things out to Mr. Adelson and asked him.
Is it really the judge's job to protect the defendant from himself, though? I mean, if counsel believed that the strategy included admitting these text messages that might otherwise be viewed as negative to them, isn't that really a strategic call on counsel's part?
If it's a strategic call that no reasonable attorney would take, I think a judge does have to step in. A judge will have to step in even under a 403 analysis, if something's more prejudicial than probative. In this case, those texts were certainly more prejudicial than probative. Yes, a judge should step in.
Even if it's prejudicial to the offering party?
Yes,
now,
sir.
I'm not going to allow you. I think that would harm yourself if you admitted that. So I'm not going to allow that evidence in. I don't think I've ever seen that.
I think in the interest of not vitiating the entire trial, a trial judge should do that, and because otherwise, he's letting the defendant walk himself into a mistrial, and a judge should not allow that to happen or be forced to allow that to happen. Based on those arguments, Your Honors, I would ask this court to affirm Mr. Adelson's conviction for his part in the murder of Daniel Markel.
May it please the court. I'll begin by briefly addressing claim 3. Here's why it was so prejudicial to my client to not get in the other text messages that the state was pointing to and suggesting that they had to have been about nefarious things as opposed to routine things. The text messages that have been proffered, they clearly are routine things. This is what the prosecutor argued in closing, page 2082. Quote, but as the defense points out, these folks had independent relationships with each other that could explain those communication patterns. So without knowing the content, how could we know if they're really talking about murder or if these call flurries around key events are just coincidence? A conspiracy can be shaped like blah, 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 and she goes on. Without knowing the content, the state objected to the jury being able to see all of the content. And now they seize upon that in closing argument and say,
I'll ask you the same question I asked the state. I mean, if these messages, which were labeled as racist, misogynist, and sexist, had been entered against Mr. Adelson, wouldn't you be arguing here that the jury was prejudiced against him in terms of this bad character evidence?
Absolutely not. Number one, that would be the actual definition of invited error. Number two, my client would be, I'm sure it's not great, but he can take the label of being racist, misogynist, whatever else. He doesn't want to take the label of being murderer. And these texts would have helped him show that what the state was arguing is not true, so much so that the state seized upon it. He doesn't need protection from himself, as Judge Winokur's already indicated. He has a right to put on evidence that he thinks is relevant. Mateo says any evidence that could be in any way, even in a slight way, relevant to the theory of defense, a judge errs in not allowing it in. The purpose of putting these texts in is not, as the trial court was saying, oh, do they go to motive or they go to any element of the crime? No, they go to showing that these are routine communications, not what the state is asserting. And he was prevented from putting that in, and the state seized upon it in closing.
Was this, if there was error, is it not harmless? He was allowed to testify about these texts on the stand.
Wow, my client was out on an island in this case. There's no question that it was, one other witness was presented. My client's testimony. Is there anything to back up my client's credibility? This would have been something that the jury could have looked at and said, wow, Mr. Adelson saying that he didn't do this. He didn't hire these people. He's the one actually being extorted. But there's nothing that supports that other than his testimony. This would have been, wow, look at the text messages. See them for yourselves, ladies and gentlemen.
How was your client on an island? I mean, certainly he could have brought forward the mechanic he was having the conversations with and all of the other people to testify about the kind of communications they had with your client.
You all know very well that I think defense counsel was ineffective and had a conflict of interest. I'll raise that at another date should I need to.
But it's clear that your client was not on an island, that there could have been evidence presented that would have corroborated what was in the text messages.
I agree, and the judge prevented it.
Right.
That's the whole reason for claim 3.
Counsel, I want to go back to something that we talked about at your initial argument about what needs to be shown to strike the entire panel. Now, I did look and I saw that this wasn't cited in any of the briefs, but I'm going to say it anyway. It's Morris, Florida Supreme Court from 2017, and the quote is, "For the statement of one veneer member to taint the panel, the veneer member must mention facts that would not otherwise be presented to the jury." So is that the correct standard to be used in striking an entire panel?
That's one aspect of it, and I acknowledge that's not met in this case. Clearly, the facts that were discussed did come out during the trial. I think the bigger issue is the expression of guilt. So I think the case that's closest on point is Brower, cited by the state. And Brower, the comment that was being made by a particular juror was they should just hang him. And this is what the 4th DCA went on to say. This is on page 1027 of the opinion. The offending members of the veneer were facing a 3-week murder trial and were enduring a tedious and lengthy jury selection process. They certainly used poor taste and worse judgment. However, there is nothing in the record to indicate that the offensive remarks were offered or taken seriously. The 4th DCA is finding that the comment, he should just hang himself, was literally a joke, not an expression of the defendant's guilt. That's not at all what we have in this case. I see them into my over my rebuttal time. I would ask this court to reverse, and I would end with this. If there was ever a case for a change of venue, these facts are that case.
Counsel, my colleague has a question,
Oh, of
so
course.
I'm going to extend your time for her to ask it and you to answer it.
Thank you.
And appropriate, your last sentence said on the facts of this case. And that's what bothers me, and I would like a response from you. The fundamental error argument. In this case, on this record, we're arguing speculation. If you're arguing fundamental error and you're asserting speculation of prejudice by the jury, in practical application, you're lowering a fundamental error standard below even abuse of discretion to me. So, on this record, your argument on fundamental error to me, I guess, help me understand what more than speculation is backing up your fundamental error argument.
Yes, Your Honor. And it would be, and I know they've been mentioned, but I will go and I have them written down right here. 40% of the jurors had formed of the 130 belief that my client was guilty. Only 1 had not, or thought that my client was innocent. 3 prior cases, as has been discussed, and one of those cases was 2 trials, one of which occurred a year before. 10 years, almost a decade, this case has been going on in this, as the judge said, small community. 2 jurors lied. So it's not just speculation. If I was suggesting that, based on this, we can suspect that some jurors are not willing to tell the truth and really tell the court that they've already formed an opinion. We know 2 jurors lied. One of those, well, both of them lied and specifically had an opinion about the case. And ultimately the jurors directly violated the court's order and talked about the case, even though the court specifically said, don't do it. When you consider all of those factors in their totality, we establish fundamental error in this case. Thank you.
Thank you, counsel. Thank you both. This court is adjourned.
All rise.
All right, we're back. Hello, everybody.
Okay, that was fun. You notice that they extended time. There was 20 minutes aside, but sometimes if the judges have a lot of questions and a lot of discussion about it, they will give them more time. I noticed a comment before, they noticed Michael Efferman wearing a bow tie.
Yes.
They said that was cool. I will note that Major Harding, for whom he clerked on the Supreme Court, also has a bow tie wearer. Just coincidence, I suppose. Maybe that's why he got hired. Well, we had our discussion about the issues that were going to be argued on appeal, that were argued. What do you think? From the questions that were asked, where do you think the judges are going?
I'm gonna be honest. I don't know. At least from my own opinion and from the comments, I think they're leaning in the direction of the state, just because I don't know. Maybe it was a vibe that we were getting from the defense attorney, but it just seemed that he was really stretching with all of his arguments.
Well, you see, they concentrated almost entirely on the two questions about the jury.
Mm-hmm.
And there was some discussion about one of the evidence issues. They never even got to the phone call. They got to the text messages. But a ruling on evidence is very easily disposed of as harmless, even if there was error. But if you didn't get the jury, if you didn't get a fair jury, it's hard to come back and say that's harmless. But you notice that the judges focused a lot on the procedural deficiencies and the fact that you accepted the jury, things we talked about before. Well, you didn't have a written motion. So you said Judge Rowe thought that was pretty important. And they discussed why you have that. And the question, and then there was discussion, well, and I think I said before we started that usually you don't grant a motion for a change of venue before trial. You wait and see if you can get a jury. And so part of that is, as Judge Wintercourt suggested, or somebody, well, what you do is you do all that stuff ahead of time. You have polls, you do things to try to show what the publicity was, whether the publicity was biased one way or the other, and what effect that there are several factors that they would have. Then when you get to trial, you try to select a jury. It's difficult. And as each individual juror, have a record of not just, well, two potential jurors lied. There have been cases in which post-verdict, people have discovered things about the jurors which they lied about and come back and use that as a basis for asking for a new trial. So it appeared to me that they were real skeptical about whether the objections were properly preserved, whether they were waived in terms of the jury. And I noticed at one time, Ufferman said, hey, look, easy fix. We got these problems, jurors are talking about, just take those out. And I think he's right. But that doesn't mean there's error, and harmless error, reversible error. He's probably right. If I was sitting at the judge, you might say, well, shoot, I'm not even going to take any chances. I'm going to get rid of all these judges, bring them in. That will avoid any objection, and I'll make sure that they're not talking about second time. But from the appellate's viewpoint, they're having to look at all those procedural things. And you notice they said, hey, you could have listened to the tape. What is it that the jurors said exactly? Well, we don't know. We only know what was reported. Was there any other comments that were made that we didn't hear about? And they declined that. The same thing to some extent on the evidence, as one of the judges pointed out. Well, there were some texts for these co-conspirators, but the other texts weren't necessarily relevant. You didn't pull those out and say, these are the ones we think are relevant. And I think that's going to give them a problem, because the jury doesn't need to hear about communications he had with his medical colleagues, his friends. We're going to have golf at this time, thing. No, I think he makes a good point that it would be relevant if I was having communications. It's not conclusive, but he's right. Probative value. So, well, if it's relevant, even if it has a slight tendency to prove or disprove something, then it's relevant. And I think Judge Wintercourt was right. You can decide, well, yeah, it's got some bad things in there, but it's more helpful to me to get it in than to get it out. And you can certainly ask the defendant or pull the defense attorney here. You sure this is what you want to do? And clear that up. One thing I did want to mention is, because you might have heard some mention that 3.850, ineffective assistance of counsel, says, well, there is a provision in the rules that up to 2 years after your conviction, I think that's the thing, you can file a motion if you think your counsel was ineffective assistance. It was so bad that you didn't get a fair trial. And some people would say, well, why don't you just raise that on appeal? Well, the problem is, because that motion would require some more evidence than what's in the record. You would basically have the attorney testify as to why they did or didn't do something, and you can't have that now. And maybe you don't understand, maybe you don't appreciate the fact that there may be an ineffective assistance to counsel. And also, if you get reversed on appeal, there's no need to have that motion. So it may seem like an extra layer bureaucratic thing that we got to jump through, but that's, I think, the rationale for having that separate motion. And yes, it was pretty clear. Mr. Heffernan was saying, yeah, well, we've got an ineffective assistant counsel perhaps later on. So do we have any questions there, Ms. Smith?
Well, I had a question.
Okay.
There was a mention of Batson challenge. Can you tell me about that? What did that mean?
Well, there's a series of cases that had to do, it came out several years ago, about striking jurors based on race. And so a series of cases, Batson being one of them, suggested that, well, we have a challenge for cause. If you're selecting jurors, somebody says something that shows that they can't be fair and impartial, they get stricken for cause if you convince the judge of that. But all the parties have what they call peremptory challenges, and there was some mention of that, which means I don't have to give a reason. I got bad vibes from this juror, I don't want them. So they say you don't have to have a reason, but it can't be an improper, illegal reason like, okay, well, because you're black, I don't want black people in my jury. Well, blah, 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 blah. I have a right as a citizen to be on the jury. It's hard to, a lot of people say, I don't want to have that right. I would gladly waive it. But the idea being that you can't strike somebody for improper reasons, and race would be one of them. That's a lot of the things that go on that. So one side can challenge a strike, a peremptory challenge, and say, well, wait a second, Your Honor, I noticed that counsel has stricken every African American that's been up here, and so I objected that. I think he's basing it on race, and that puts the burden on the other side to show they have some other non-racial, non-discriminatory reason to strike that juror, convince the court of that. So that's that series of cases.
Thank you. It looks like we've got a question here saying, wouldn't pulling a community bring attention to the trial by potential jurors that may have not heard of the case initially, but then cause the community to kind of talk and research the case?
Well, it could, but if that were a person, these polls are done with a fairly limited number of people. It's not like they poll everybody in the community. But if you came up, you were a potential juror, they say, have you heard anything about the case? Well, I didn't follow on the news, but I got this survey that I answered. And if I hadn't heard about the news, then that made me interested. So I went and researched it. So it may be that juror would be set aside, but it doesn't mean that that person would then go out and talk to all their family members. As I think the attorney for the state said, it's really an individual juror type situation. Can I get a jury that says, I haven't heard anything about the case, and or I've heard something about the case, but I can set that aside and make my decision based only on the evidence and the law that's presented to me. That's the key issue here. And that was, I think you could tell from the questions that were asked, a concern of the court that, well, yeah, you got all this stuff, but in the final analysis, you got a jury of people who said they could be fair and impartial, some of which had not even heard about the case. And you have to basically speculate based on the fact that two potential jurors, in fact, were caught misrepresenting the facts, we'll say, that these other people were too. But like I said, there have been instances where people have post-verdict gone and found out that jurors who sat on the case had lied about it. For example, no, I never heard anything about the case. And they come in and they find like one of the potential jurors, well, that's funny because you posted on your Facebook page all about it. But that wasn't done here, obviously.
Gotcha. Well, what do you think overall? What do you think?
Well, like I said, I think the court focused on the fact that the necessary preservation of the objections, the motions, etc., was not done here. And Ufferman had to argue really strongly that at least you can review it under fundamental error. We talked about what a high bar that is. But obviously they were concerned of those two issues. They focused a lot on whether you get a fair jury. And they did ask Mr. Lee a lot of questions too, but I got the impression some of those questions were friendly, an opportunity to say, well, this is what I think. Yeah, I agree with you, Judge. Overall, like I said, it's very difficult to get a reversal on appeal. And I think the questions, which you could see that both the attorneys and the judges were well prepared on the law and the facts. Everybody knew it was in the record. The only thing that I thought was, and I forget the note of it, but where they said there was, well, I'm not sure. But one thing, when I read the record and what was represented, it wasn't quite as was assumed here, but I forget now what that was.
Okay. A lot of people are asking, how long is it going to take for them to render a decision?
Sometimes appeals take a long time, and I wouldn't suspect after oral argument, because by now, obviously, the judges have read the briefs, they've talked about it, they considered it, they had their own questions. They'll go back now into a conference. 3 of them will talk about it. They'll see if they can agree on what their ruling should be, and one of the judges will be assigned to write the opinion. There will probably be an opinion. Sometimes judges write what's called a PCA, a per curiam affirm. They don't really discuss the case at all. They just say affirm, which is frustrating for lawyers. I say, well, at least address, but I suspect in this case there'll be some opinion, some discussion about the issues raised, and it should be sooner than later, because it's been on appeal for quite some time. I mean, the conviction was 2023, so maybe a few months, I would say. It could be longer if they go back and they discuss it, and it's hard for them to come to consensus, or they go back and forth, but I suspect a few months.
Gotcha. And I haven't seen, maybe there's some more questions from you guys that are listening. If you've got some questions, go ahead. I'll give you a few seconds to go ahead and comment them. Oh, here's one. If the appeal is denied, is there any recourse for the defendant?
Well, as what was suggested here before, and happens quite often, it happens a lot with clients of public defenders. They don't have any money. It goes up. They always get a right to appeal. If you're not indigent, you have to decide whether it's worth it. I think somebody asked at one point, how much does it cost you for an appeal? If you have a private attorney, quite expensive. We're talking 3 figures usually. So if you can't afford that, but you have a public defender who's appointed to you on appeal, they can do that. But there's also, as was suggested, once the appeal process goes forward and the court affirms the conviction, you have a certain amount of time to file any post-trial motions, and almost always, sometimes it's like, oh, discovery of new evidence that I didn't know about and couldn't have discovered, and we want a new trial because of that. Most often is, my counsel was ineffective. He or she was so bad that I didn't get a fair trial. They should have done this, they should have done that. And you heard a lot of comments about that, which might give you grounds to do that. So yes, there's that remedy. And again, those are rarely granted. But what the court looks at there is, okay, did the trial counsel do something that any reasonable, rational trial counsel would not have done, or vice versa, didn't do something that they would have done? And 2, would that have affected the trial? That's going to be difficult on the jury issues, because we don't know. We just don't know. It didn't preserve the error. We have no idea that if that had been done, if he had objected, for example, no, Your Honor, I object to this jury panel on the grounds that I urged before. Okay, it's preserved, all that stuff, but we still don't know if he hadn't done that. We don't know whether that would have made a difference for the reasons the judges were suggesting there. We don't have the affidavits that would generally go with that. We don't have any evidence that the other jurors who said they could be fair and impartial had lied. So yes, there are remedies available, but again, high bar for the defendant.
And here we've got another question from the mentor lawyer. If Charlie gets a new trial, will he be stuck with the extortion defense if he takes the witness stand?
Well, he's not stuck with it, but he'd have a very difficult time coming up with something else, because if he takes the stand and says, I don't know, whatever that other defense might be, the other side's going to come up and say, well, isn't it true that you had your trial and here's what you testified before? It's as we've just been learning in evidence, one way to impeach a witness is a prior inconsistent statement. So the object is, well, you can't believe this guy. He said this on one occasion, he said something completely different on another occasion at trial. So his credibility is significantly diminished.
Now here's an interesting question. I feel like these kind of appeals are dangerous. Won't it set a precedent? We all know it's getting harder to find a person who hasn't been exposed to social media?
Well, I think in general, as was suggested here in this oral argument, as opposed to 20 years ago or more, we didn't have the extensive coverage. Now everybody with a microphone is a journalist, and everybody that can write a blog is a journalist. So yeah, there's a lot of media exposure, and the danger is if you go on any of these things like Facebook or whatever, people are always posting things, and who knows whether they're true or not. But sometimes people hear it and they say, oh, okay, yeah, okay, now I know what it is. It's always going to be a question, and more exposed. The question is, as was suggested here, people will hear that, and some people take it as true, some people are skeptical. So it boils down to, are you able to select a jury? And, pre-trial, they can take some precautions to try to minimize that exposure, but you're always going to have it. And interestingly enough, as suggested there, a lot of times people don't do that. You'll get a batch of people, and a number of them, no, I'm not on social media. I don't really watch the news. I don't read the newspaper. It's all depressing. Why should I listen to that? Or they look at, I didn't pay much attention to it. I scrolled down Facebook and I saw some comments. So, and I like to think, and I do believe that people are try to be honest and they try to be fair. And I believe that they're conscientious if they're selected to be on a jury to follow the instructions on the law and to base it on the evidence. I do believe that. And in the 30 years I was on the bench and the many trials I had, very, very rarely did I ever have a verdict come back and I went, oh my God, what were they thinking? That kind of thing. Sometimes I might disagree but that means people disagree. That means I can see where they came up with a verdict, and it wouldn't be unusual. So, it's a problem. It's going to get worse because we're going to have with AI, and it is now. People, they'll have. Here's what. I'll give you an example. There was a case of notoriety down in the middle of the state in Orlando, and I can't think of the name of the defendant, but supposedly killed her children. It got a lot of publicity, and I know the judge there, Melvin Perry. We were at a judicial conference one time, and we were talking about the internet and social media and all the ways, the idea that people can, what do they call it, figure out a way to look like it's you posting something. Somebody created a website for Barry Pelvin, and he was quoted as saying, I knew she was guilty, which wasn't true. But the idea being, they put up false stuff all the time. And it's going to be difficult to determine with AI whether this is real or not real. And people with an axe to grind or people with some ulterior motive can do that. So we hope that, but we still become objective.
Here's another one. Could there be an argument for, this is kind of switching topics a little bit, but could there be an argument for invited error if Charlie claims ineffective assistance of counsel due to Rashbaum's conflict if there's evidence of coordination between the co-defendants?
I would say yes. And for those of you that, I think the issue there with his attorney was that he also represented Donna Adelson. And at first they waived that conflict, and then later on said, well, we have a conflict. And it's sort of like, well, here we are on the eve of trial. Now you say, no, we're not going to go that route. That's still preserved if they did it. And if they decide there's a conflict, they would have to show that. And certainly if there was evidence, I don't know how you would get it because all those communications between the attorney and the clients are confidential. And somebody would have to waive that unless they said that to a third person. Maybe they talked to Harvey or maybe to Wendy or somebody to say, this is our plan. Yeah, that kind of stuff wouldn't work too well for you. And it's difficult during the trial to think about ineffective assistance of counsel and how to protect against it in terms of motions or evidence and things like that. I do know that there's an local attorney that I always expected he would do something when we selected a jury, for example. He would he would lean over to his client, Mr. So-and-so, have I selected a jury? Have I done what you wanted me to do? Have you looked at all of them? Do you agree with the selection of the jury? Is there any problem you have with my representation? Go through all that, which is not conclusive, obviously, because they'll say, well, I don't know, I'm not a lawyer, but I later found out. But it's helpful. So if they did that at some point, and that always happens with, if a defendant intends to testify, the judge does a colloquy with them, asks them questions, because it's their decision, not counsel. That is not something that the counsel can decide for him. So they'll ask him, have you had a chance to talk to your attorney, the pros and cons, et cetera, is anything, I guess. But it's your decision that you want to testify or not testify, whatever the decision is.
There was a similar question. Maybe I can find it. Here we go. Now, can Donna, when she appeals, say that Judge Everett, or the presiding judge on Charlie's case, can she say, make some claim, make some argument that he was prejudiced against her or pre-decided because of also overseeing Charlie's appeal?
Well, I saw the sentencing, or when the jury verdict, maybe the motion sentencing, I think it was, when she made that comment that she thought the judge was biased and didn't give her a fair trial, and the jury was biased and didn't give her a fair trial. So I suspect some version of that argument will be made by Donna. But it's going to be difficult. Was there a motion to disqualify the judge? No. If there wasn't, well, then you waived that right. Is there something the judge did during the trial? Well, that's what appeals are for. If he did something that suggested he was biased, you could still, even during the trial. For example, if Everett had, during the trial of Donna, came up, well, I tried your son's case and he was guilty. I knew that before, and I know you're guilty. Whoa. And that's not something the judge should say. And you say, and that has to be in writing too, by the way. So he said, Judge, can I have a few minutes to write out a motion to disqualify you as the judge? And the judge would have to do it. And the thing about that is, if you present a judge with a motion that, if it is true on its face, even if it's untrue, the judge has to accept it as true and remove themselves, if that would give grounds to do that.
Gotcha. Thank you. I haven't seen any more questions.
Okay. Well, listen, this has been fun, entertaining, informative.
Sure.
I did enjoy watching the oral argument. I hadn't done that in a long time. But I hope you enjoyed it. And I'll do this again sometime. I'm not sure when, but like I said, I'm interested in this idea of justice and how law and justice fits together. It doesn't fit together sometimes. And we'll explore that in future episodes. Yep. So thanks for tuning in.
Sounds good. Thanks, everybody. And we'll see you next time. Bye.